Welcome to the Trade Finance Distribution Initiative podcast. This is the home to a business community of banks and non-bank financial institutions and stakeholders who are carving out the future of a more liquid trade finance. I'm Doris Kudinovich, and today our guest is not a financial institution, but from a statutory independent body that keeps the law of England and Wales under review and recommends reforms where it's needed. So if you're keenly involved in the ETD bill, you're definitely going to get the scoop and the inside gist of what's going on there, because we'll be hearing from Sarah Green. She is the Commissioner for Commercial and Common Law at the Law Commission of England and Wales. Great to have you here, Sarah.
Thanks for inviting me. Nice to be here.
Really delighted as well, because this is episode 20, and I'm a little bit ashamed to say that you're the first female on the TFD Initiatives podcast. I'm really ashamed, but I'm very excited, and hopefully we have more ladies as well joining the podcast, because I do love to see a little bit more representation within the trade finance and finance in general
Yeah.
industry. So can you just give us a little bit of an insight as to what you do at the Law Commission?
Yeah, absolutely. So there are 4 law commissioners, and between us, we keep the whole of the law of England and Wales under review. So as you've already said, the part of that I look after is commercial and common law. My colleagues look at criminal, family, trusts, and public law. And I have a team, and at any one time we have between sort of 4 and 6 projects ongoing. Each one of those projects has a dedicated lawyer who leads it, and at least one research assistant as well. And these people get to spend all day, every day, or at least the working day, considering a particular area of law, whether reform is needed, consulting with a wide range of what we call stakeholders, basically anybody who is interested in that area of law, whether they are the end user, legal advisor. We discuss these issues with judges, with academics. And so that lawyer and that research assistant spend their days doing this and coming up with suggested law reform, as you said at the beginning, where that is needed. It might be, and sometimes the answer is that it's not needed. And we don't regard that as a failed project in any way, because what it means is that we've asked the right questions.
I mean, you have such a combination of great minds working with you. I'm quite curious as to what the background was. It must be such a variation of backgrounds within a law that you kind of work with. Can you share a little bit about that?
Yeah, absolutely. So basically, the makeup of the Law Commission, the research assistants that I've just mentioned, they tend to come to us straight from university, and they do a year with us before they go into practice or academia. And then the lawyers, the team managers, and then the commissioners are either former legal practitioners, so they've either worked in law firms or at the bar, and our chair is actually a Court of Appeal judge, or they're academics. So that's really good, because we get it's a real melting pot, of different types of legal experience and legal wisdom, and in many cases, genius. So we get what might otherwise, I suppose, be seen as a sort of ivory tower, very theoretical approach. There is that, but it is balanced with a very practice orientated and pragmatic approach. And I think that's what makes the Law Commission unique and good at what it does, because, to be quite honest, we need both of those things. So we need theoretical rigor, but we also need pragmatic and practical reality, and that's what we get.
That's exciting, and now let's look at, as a case study, the digital trade in 2021, which triggered off the development of the electronic trade documents bill. I think it's incredibly exciting. Can you tell us about the journey of creating this bill?
Yeah, so it is. It has had a very interesting journey, and that's partly because right in, I suppose, what is the middle of that journey, we had the pandemic and we had lockdown, and that's really important. A really important part of its history, actually, because, I mean, in essence, what the Electronic Trade Documents Bill aims to do is really quite a small thing in one sense. I mean, it certainly sounds, and will sound to non-lawyers, like a very small thing, but its influence is massive. So basically, all it is trying to do is to enable electronic forms of electronic forms of documents to have exactly the same legal effect as their paper equivalents. Because, realistically, most commercial parties in this day and age do not want to have to use paper anymore for all sorts of reasons. It can get lost, it can get burnt, it can be easily forged. It takes a long time to send from one side of the planet to another. So they want to use electronic documents, but actually there are various legal reasons why they can't at the moment have those documents can't have the same legal effect as their paper documents. So all this bill is trying to do is make that a possibility. So as I said, I think lawyers will probably look at that and think, why didn't that happen a long time ago? And that's a very good question. But the reason the pandemic is relevant to that is because obviously during the pandemic, during lockdown and social distancing, it was very difficult to do things in a physically connected way. In fact, sometimes it was illegal to do it. So it really made it obvious, I think, to governments and to organisations who have the power to make these changes that actually it is very anachronistic now. It's unrealistic to expect parties to transfer documents in paper form physically from one hand to another. So it's been a fairly long journey for something which sounds so simple. It's not quite as simple as it sounds because in English commercial law, we have to be very careful. So much of it works so well. We have to be very careful that in changing one little thing, we don't break lots of other
Yeah,
things.
it's
So
a
that's what
spider web, isn't it? Yeah.
yeah, exactly. But it's now happily, hopefully near the end of its journey. It's had its second reading in Parliament. It's going through a Law Commission special procedure, which usually means that things can happen slightly quicker than otherwise. So fingers crossed, it will become law next year. I mean, there's still certainly no guarantees. Of course, it's subject to the democratic process, but that's where we are.
I think that's such a fascinating place to be. And just thinking about it, you kind of answered a bit my next question about why now. I mean, since the times of the Venetian merchants, trade has been happening quite manually and even paper wise. Was it just COVID that influenced the decision to actually kick off the investigation of having this trade bill, or were there other challenges or circumstances that actually made the government think maybe this is something now we need to kind of approach the Law Commission and think about why this is necessary to push forward?
Yeah, there absolutely were. So the pandemic and lockdown, I think, were catalysts to a process that had already started, and that process had already started, I think, primarily because um, distributed ledger technology meant that in a very practical and realistic sense, it was possible for the first time in a scalable and accessible and sort of relatively mainstream way to make electronic documents have the same characteristics as paper documents. Because what's really important in a legal sense with these documents is obviously if I have a piece of paper and I hand that piece of paper to you, I no longer have that piece of paper and you have it and you can send it on or pass it on or transfer it or do whatever you want with it. Whereas until DLT, so distributed ledger technology, that wasn't very easy to replicate in electronic form. So if you think about, say, a Word document, I can pass that on to you, and most of the time I keep a copy, and that can be sort of almost infinitely, duplicated, which is no good for a document that has to represent legal rights. Because, say, if a bank is advancing money on the legal rights in that document, it's not going to be very happy if there are several copies of that document circulating. So first, I think it was DLT and basically the technological possibility of replicating the characteristics of paper. And it's a bit of a snowball effect. So I think once certain governments started to recognise that this was a possibility, so we had Melita, the model law of electronic transferable records. Singapore, for instance, as a jurisdiction, passed legislation to do exactly what I've been talking about and allow electronic versions of these documents. So all of those things combined, I think, were what really led to our government sort of sitting up and taking notice of the need for this. And there was also a huge amount of understandable representation from industry.
And were there stakeholders who were otherwise involved in helping to push this bill? I know like ITFA has always been quite interested with the DNI and TFDI. Who did you kind of work with in terms of getting the supporting argument for this bill?
Yeah, you're absolutely right. It was really, really helpful from the start, both in terms of getting the message out that this was something that needed to happen, and also in terms of helping with our consultation on the substance. I think probably the biggest player in terms of bringing this to the sort of the collective consciousness in government was really the ICC, so the International Chamber of Commerce. They were incredibly helpful, and obviously the interests that they represent are very broad. And so, they're a good person, a good legal person, like a good organization to listen to. So I think they also commissioned some research so they could provide statistics in terms of how helpful this change could be legislatively, and also in terms of environmental issues as well. I think it was they who first brought to my attention just how many trees this change would save. I mean, I can't remember the statistics now off the top of my head, but they're easily accessible if you Google them. I mean, it really is quite a phenomenal number of pieces of paper that currently change hands that just simply don't really need to in that form.
It definitely is quite paper heavy, transactions alone, let alone, on a global scale as such. So where are we next? Where are we with this bill? I know we've heard rumors of it, moving to the next stage. Can you give us a bit of intel of what's happening now?
Yeah, so all I know is that it goes to committee stage, and that's the sort of exciting bit in the sense that in committee, that's where the houses really get, I mean, houses of parliament really get into the minutiae of it, and they really discuss it. I mean, the first and second readings are a bit more procedural. They're a bit more provisional. They do require consent from the members, but it's really at committee stage where we get into the detail of discussion. We have to wait and see what happens there. I should say that this is originated with the Law Commission, this bill. It's actually being taken forward by the sponsoring government department, which is DCMS. So Digital, Culture, Media and Sport. So technically now it is their bill. They're sort of running the show in terms of taking it through Parliament. I mean, all the signs. I mean, as I said at the start, nobody can make any guarantees because we know what the legislative process is, and quite rightly, the democratic process means that it has to be discussed and it has to be analysed. I think the encouraging thing is that most of the responses to it at second reading were definitely supportive in terms of the idea of the bill and the objective of the bill, and there was widespread, if not universal, recognition that this is a change that would be a very valuable one, and there aren't too many downsides. So I think it's a bit more now about exactly what the detail of that change should look like.
Yeah, it's a really promising 2023 because, as you said, there really, hopefully, no downfalls to actually progressing something that would ease business, save the planet, and really, help us to liquidate funds and look at trade finance and make it an attractive asset class. Right, you're still listening to the Trade Finance Distribution Initiative podcast with Sarah Green. She's the Commissioner of Commercial and Common Law at the Law Commission of England and Wales, and we've been talking about electronic trade documents. Now we're moving on a little bit now to digital assets, which is a piece of work that you've been dealing with a bit. Can you tell us a little bit more about that?
Yeah, so this is a lot more complicated and wide-ranging than electronic trade documents, but actually the fundamental concepts are very, very similar. So the Electronic Trade Documents Project is really a sort of, I suppose you could say, a subset of digital assets, because what the Digital Assets Project is dealing with is how the law should treat digital assets, and those digital assets being anything from a virtual currency, in terms of it's being treated as an asset rather than a currency, so as an investment. And it also includes things like NFTs, non fungible tokens, tokens on a blockchain, which represent either an on chain asset or an asset in the real world. So, all of those sorts of things, basically, at the moment, mostly things held on a distributed ledger. Um, this project looks at how the law should treat those things, because the worrying thing is that it's not currently clear or certain, either in this jurisdiction or anywhere really at the moment, what those things are as a matter of law. What is their legal status? And it's even true to say that it's not clear what your rights are if you think you own one of these assets and somebody takes it away from you, basically. So if somebody, say, hacks into your wallet and removes or deprives you of your digital assets, it's not clear what your remedies are at law. And I think people would be very surprised to learn that. If somebody takes my laptop, or they take my car, or they take my watch, it's very clear to me, and it's certainly very clear to the legal system, what I can do. I can sue if I can find that person, but I can sue for the market value of that thing. We don't know that that is true for digital assets at the moment. And we also know, not as lawyers, but generally, that people are spending huge amounts of money on these assets in some cases, and investing large amounts of money. And it would probably surprise and maybe frighten them to learn that actually, these legal rules are not at the moment at all certain. So that's what our digital assets project aims to do. So in the sense, it's sort of like electronic trade documents, in that we're trying to bring the treatment of these electronic, non-conventional assets within the treatment that the law is used to doling out, basically. So what we propose in the consultation paper that we published in July is that these things basically, I mean, it's a very long paper, it's nearly 600 pages long, but the headline points are that these assets should be the subject of property rights. They should be protected in a way that is analogous to the way that conventional tangible assets are treated. And it sets out the detail of how exactly that works. And it also puts a limit on which assets fall within that and which don't. So what's really important about the digital assets we cover is that they are what we call rivalrous. So kind of like the what I was saying to you about paper. If I'm holding something, if it's a piece of paper or a watch, say, if I'm holding it or wearing the watch, you can't wear it at the same time. But if I transfer it to you, I can no longer wear it. I mean, that sounds like a really kind of facile point, but actually
No, but it
legally
makes
it's really
sense.
important.
Yeah.
Yeah. And that these things are independent of people and independent of the legal system. So they're different to, say, debts, right? So if I owe you money, you have a legal right against me. But that right only exists because the legal system recognizes it, and because you and I are around to enforce it, or at least you're around to enforce it. Whereas a token on a blockchain exists in the world, independent of you and me, and regardless of whether or not there is a legal system that recognizes it. So as I said, it's a very long report, but I think that the idea is basically a simple one, that these digital assets are actually a lot more like conventional assets than they appear at first blush, and that the law needs to catch up and recognize that.
It's a very necessary conversation to have because with emergent digital assets now, spearheading, there needs to be some safety and guarantee that we know what happens next. And I just wanted to point out something about, obviously the UK law holding the one of the primary laws around the world. Are we looking at becoming like the hub for digital trade assets industry? And if yes, what is it that we would want the whole world to follow? Because when we're looking at this is UK law, but other countries may take this and adopt it as to how it affects their countries. So, how are we aiming to be the top head here in terms of digital assets, and how so? How so?
Yeah, I mean, I think, as you've said already, the law of England and Wales is incredibly important across the world, and it's one of our greatest economic assets. I think it's a really good export, and so I think we have a responsibility really, that if commercial parties are looking to the law of England and Wales to cover their transactions, then I do think we have a responsibility to make sure that the law that they choose is fit for purpose and is the best it can be. Um, and so I think that's definitely my aim personally, and I think that is the aim of us as a jurisdiction. And I think what's really important about English law historically is its certainty. I mean, that's a lot of the reason why commercial parties across the world do choose it. Its certainty, its due process, the fact that its courts are trusted and they're very long established. But I think what's really important is that um, the Law Commission, as I alluded to at the start, is quite a unique institution in that when we get a project like this, it is all we do. We have the time, we are given the funding from government to live and breathe these ideas and these problems and these issues. It's actually very few institutions around the world that are actually given that time to spend thinking about these issues. And we do actually work alongside other law reform bodies. So we know what other jurisdictions are doing. I think we're the first to produce a paper and an analysis of the length of our consultation paper in July, and that has certainly been mentioned in other jurisdictions. It was certainly referred to in the Celsius bankruptcy case in the States very recently. And so I think not only are we aiming to be a hub where parties can feel that they can transact with these new technologies and it can be very clear to them what their liabilities, what their rights, what their obligations are going to be. But I actually think we're already quite a long way down the road in terms of having done that analysis and having consulted um, not only stakeholders in this jurisdiction, but across the globe. We've had as many conversations as we could possibly fit in. So I think we're a long way down that road, as I said. And actually, that's another point that the pandemic and the lockdown have also indirectly helped that consultation, because what, of course, they opened up for people was the ability and the recognition that actually interacting like this, or on a screen, you don't necessarily have to be in the same room, you don't even have to be in the same continent, and you can have really useful conversations. And that's been amazing for the Law Commission, because we have been able to consult with a far broader base of stakeholders in a much shorter time than we would otherwise have done. So yes, I think we're in a very good position to be able to say to parties across the world, if you come and do business here and you choose for English law to govern your transactions, the following will apply. And I think that's really important. That's what parties want to hear.
No, definitely. And you're looking into this in a very granular level as well, focusing on it entirely. So I'm interested to know what other areas or what other laws within trade finance do you think the Law Commission will be looking into in the future, if any?
Well, we're already working on two things, which I think will what's the word? I suppose interact with, overlap with, and I guess in some cases impact directly on trade finance. So we've got a project, it's in its very early stages, but we've got a current project on decentralized autonomous organizations. So essentially, stacks of smart contracts which automate agreements without the necessity for human intervention. And whilst they're already being used quite extensively in some sectors, again, it's something that's not clear in any jurisdiction so far as I'm aware. Maybe there are a couple of jurisdictions in the States, but it's an open issue. It's an open question, I think, in many places still. If you set up a decentralized autonomous organization, so a kind of software-based coded company, I guess is the best way of putting it. If you do that at the moment under English law, it's not clear what sort of a legal creature is that? What legal status does it have? If you set up a sort of conventional company where you have people who are directors and people who are shareholders, it's quite clear what model you can select from the sort of legal menu, if you like. And then it follows from that, and you can easily find out what your liabilities are, what you have to do, what your responsibilities are, so on and so forth. But if you set up a DAO at the moment, it's not clear at all. And so actually, if you're going to set up an organization, obviously it's really important for you to know what your risks are and your liabilities and so on. And so it's really important, I think, for us to make sure that that's clear. The way is clear for people to do that with DAOs, with decentralized autonomous organizations. And actually today, as luck would have it, in fact, about an hour ago, we published our call for evidence on that project. So that's on our website as well. So as ever, we welcome views on that. And then the other one, which I think is going to be important for trade finance and trade finance participants, is one that we have on digital assets. It's called What Law, What Court? And basically, there is always a problem with international, or I should say a potential legal problem with international transactions, which is not always clear. If you have people from different jurisdictions contracting with one another, it's not always clear which law should govern their agreement and which law should therefore govern their dispute, and also which court their dispute should be heard in. Now, this has obviously long been an issue, and so there have been traditional rules in place for a very long time. But some of those traditional rules are based on questions like, say we're having a dispute about property. One of the questions is, well, where is the property located? And if we find out where the property is located, that will give us some guidance as to where that dispute should be heard and what law should govern it. But of course, if we're talking about digital assets, that question, where is the property located, is neither easy to answer in all cases. I mean, some people would say, digital assets on a distributed ledger are everywhere and nowhere. I mean, that might not factually be true, but the other thing that arises is, the other question that arises is, how authentic is the question? Where's that property located? Does it really matter with digital assets? So that's another one of our projects, and that's in its early stages as well, that we're working on at the moment.
That sounds really exciting. Now, for our final question, I want to ask you, of all the recommendations that you've made, which has been your favorite that has gone through and passed?
Well, it might be jumping the gun a bit to say, but so I'm going to give two answers because they're sort of connected. It is jumping the gun a bit to say, but even if it gets no further than it is now, I am delighted about electronic trade documents, because I think, obviously, I really, really hope it passes. And this is an idea that, as my previous life as an academic, I wrote about intangibles and the law's treatment of them for nearly 20 years. So I've been trying to argue for this sort of change for nearly 2 decades. So if that gets onto the statute book, I will be delighted, mostly for the industry, mostly for the law, but also a little bit for me. And even if it doesn't, I think that there's been enough momentum now in this jurisdiction that other jurisdictions will do it. And so I'm relatively optimistic that it will happen at some stage anyway, even if this doesn't actually become an act. And then I think really connected to that is the work we've done on digital assets. As I said, it's the same sort of principle, really, getting the law to recognise that these things might look a little bit different to conventional assets, but that in a lot of ways they're functionally the same. So if that idea gets traction within the law, both in this jurisdiction and abroad, I'd be over the moon.
I mean, 140 years, eh? We've been doing things the old way. It's not too late now. Come on, 140 years. It's ripe.
Yeah,
It's literally
yeah,
falling off the tree now.
but
We're ready for this bill. Well, Sarah, that's all the time that we have for today. You've been an amazing, amazing guest. Thank you so much for making the time on the TFD Initiative podcast today.
it's been a pleasure. It's been lovely talking to you, Doris.
And it's your turn out there to tell us what you think. Join the conversation on our YouTube page and subscribe to all the various channels to stay in the loop and stay informed of all what's happening on the TFDI. This has been episode 20. Go out and do great things. I'm Doris Kuninovich. Till next time.